Morning, everyone. Let's see what we got here. My video is starting. All right, there we go. Let's see, comments. Yeah, I'll keep an eye on this. All right, we'll get going here in a second. Let's see. Let's get this together. And give it just a minute more here. Hope everyone's doing all right today. I'm going to pop down in here, see if I can kind of keep an eye on comments. Hope everyone's doing well this morning. We're going to go down the kind of the status on where a lot of the bills are right now, and the in the broad sense right now, where we're at is that of around 28 bills that affect medical marijuana policy here in the state. Of about 28 of them, it looks like there are 2 or 3 at this point that still are intact enough to go through the rest of the process kind of in regular order, what they call. So there are a handful of bills that could receive a vote and get to the governor fairly soon. The vast majority of it, and basically all of the stuff that we voice concerns on, the majority of that is all most likely going to have to go to what's called a conference committee. And so what'll happen is the committee will come together of both chambers, and they'll sit down and they'll look at the pile that they have, and they will they'll conference, and they'll come out with language that they are looking to then pass in both chambers, and that'll all happen, fairly quickly when it happens. So we're gonna have to keep an eye on that. But the first thing is that we've made a lot of progress. Folks, we can definitely see there are a number of changes to bills at the end of last week. We can see where progress was definitely made. Your voices are being heard. So that said, there are a number of bills. We're looking at out of about 28, and if you guys go to the Google Doc, I've got this stuff shoved up at the top of the Google Doc, and it's got the blue link is to the live bill as it sits right now. Some of those are still being updated by the state, but we're keeping those there. And then there's a color code that's basically a red, yellow, green type of coding system, where red is the stuff that we are just not good with right now and wouldn't be good with as written or probably in the ballpark. Some of those just need to die. The yellow is stuff that it's good intent, could probably use a couple of tweaks here and there to improve. We're starting to suggest some of that, and we'll talk about those today. And then the green is stuff that, for all intents and purposes, looks, passable to us. It's net positive, net neutral, maybe improves things a little bit, so you let, gotta green light some of that stuff. If anyone looks into these and sees what they are and has any concerns, this week is the time to speak up. If there's something that you think needs to be changed, if there's something that we're saying okay that doesn't look okay, let us know. It's all of our perspectives together that is what makes for the best overall package here. So let's what I want to do here, I want to do something real quick. And everyone, I want to let y'all know that I just got a call that state questions 818 and 819 have been cleared by the Supreme Court. So SQ 818 and 819, we are now throwing it into gear, and we look to be gathering signatures by roughly Memorial Day weekend, if not maybe a little before. These become certain timelines now that we're clear of the court. We'll do another live tomorrow after we've had a chance to review everything that's going on, and we'll, keep folks updated there. But for now, let's run down this legislation. What I'm going to do is I'm going to hit the green lighted stuff first, and we're just going to kind of clear the deck with it. Y'all check the doc. Let me know if there's something wrong. But, just to show how much, stuff is clear, and then we'll kind of go into the stuff we really need to be watching. So let's see. House Bill 3752, which is basically a penalty for abandoning a grow site. It's targeted at illegal grows. That 3752, that one's fine. Senate Bill 1841 allows OMA to suspend or revoke commercial license for failure to comply with rules of other applicable state regulations. Okay. 1841 was one of the bills that all this time up through last week, before it received basically a committee amendment, and it's the one where it was set up that if you say got a municipal penalty for not having the grass mowed outside the dispensary, or there was any violation at any level of any ordinance, and they would notify OMA, and OMA would cancel your license in 30 days if that was not, remedied, which is wholly ridiculous. And so we'd all been talking a lot about it, and a lot of y'all have been calling on it, and it's been amended. So Senate Bill 1841 now is written that if you have a violation, you basically get an unresolved issue with a state agency. Let's say in this case, and it lists them out. It's like Light Propane Board, Water Resources, all of the agencies that also come in and regulate what any typical business does, any typical agricultural operation does. There's nothing really in it beyond parity with all other businesses, and that's all we ask. So it removes the, kind of the municipal provision there, and so we don't have to worry about, anti-MMJ municipalities, picking on us. It doesn't allow that. So it has been modified, and it's been modified to where it went from the red zone over to the green zone. And so that's great. That's wonderful. That's great progress. Thank you to the, legislature for listening to our concerns there. Let's see. 1755, Senate Bill 1755, which is a temporary license application. It's a good one because it allows for a temporary license, but that's basically what it does. So if when you start a build out, say in a municipality, and you're, doing an expensive build out that's going to take time for, say, a certificate of compliance to be able to be done based on a certificate of occupancy. You can put your marker down, and that's that's a temporary license. And so it basically, you do your regular filing fee, your regular license fee, and you get a temporary license, and then it can be activated once you can get your certificate of compliance. So Senate Bill 1755, good bill. That's moving through. There's no other real stipulations in 1755. It's just real clean. House Bill 3083 is a budget allocation of the 7% excise tax on MMJ. So it's where they're spending the money from the excise tax. And it goes along the typical split of money for OMA, money for education, money for mental health. However, there's a caveat to this. So 3083 as it is, House Bill 3083, that's fine. Send it through. However, what had been pointed out in House floor debate was that there's a bill, House Bill 3530, which is the bill that creates the County Sheriff Public Safety Grant revolving fund. And that is the fund that would be created to bring in to basically give grants to county sheriffs for them conducting enforcement activity. And so uh, and so that bill right there, it indicated that they're going to spend these dollars, this $5 million into this grant. However, it didn't say where the money was coming from. On floor debate in the House on it, the author indicated that the director of OMA had assured him that she would get him the dollars. Well, as we all, and nothing against anyone, but we all know that these things, if that's what's going to happen, is better in statute, so it's known, okay, this is what's going to happen. And so I bring this up to say, okay, so this is out there. This House Bill 3530 is out there. It's not necessarily bad. The dollars from 788 were meant for enforcement of the program first and then the others. So, I mean, they're kind of within bounds here on that principle. So what we have also is we now have Senate Bill 1848. These three play together. So House Bill 3083 and Senate Bill 1848 were bills that were basically the same thing. They did the same thing. They were mirrors of each other. So, but what has happened now as an amendment is that 1848 has now identified that should House Bill 3530 pass, that those dollars would come from that 7% excise tax. So they did some house cleaning there to, make sure that there wasn't conflict and, everything was stated very clearly about where the dollars were coming from. Let's see, House Bill 3634 is the wholesale license. Good bill. House Bill 4411 removes a limit on the number of inspections that OMA can do in a year. I mean, they've removed it by themselves anyway, so sure. House Bill 3813 gives OMA investigators full law enforcement power. Again, this is where there are like 4 to 6 of these folks that are the investigators. They're not the inspectors. They already are all CLEAT certified. And so the thing to know is that what this would do was it would allow them to enforce other laws at locations that they are. So yeah, if they come to do an inspection on something and you're breaking the law or whatever on something else, they can do something about it if this bill passes. So it basically gives OMA investigators, not the inspectors, gives 4 to 6 investigators full law enforcement power. Let's see, House Bill 4288 requires expiration date on edibles, which is just kind of common sense consumer safety. Almost done with the stuff that's basically good. I'm going to dive into the comments and see if there's any, quick questions. Let's see. I don't have the bill number down. I realize I lost track of it, but I know it's out there. It's alive. There's a bill to allow dispensaries to get 280E tax deductions at the state level. That's a great bill. That's one of the only bills, if any, in here that actually bring parity to businesses in tax structure. I mean, that's those are kind of the values that a lot of folks talk about sticking to here, and that is, let's lower the tax burden. Right now, we pay a way higher tax burden than everyone else already, and it'd be good to get parity there. So let's see, House Bill 3287, which requires outdoor grows to get into the sensitive crop registry. It's typical with other sensitive crops. It's there. It takes a few minutes on ODAP's website to do it. We've got the link to that in the doc. Should this bill pass, we'll make sure everyone's got the link of how to go do it. Probably give a rundown of how to register one. What it actually does is it protects outdoor growers from overspray from aerial sprayers and other sprayers of herbicide and pesticide, but specifically herbicide. So right now, if you are in the sensitive crop registry, which yes puts you on a map, but we're all on a map publicly available with OMA right now anyway. We don't want to be targets, but they're also access to this map is also somewhat restricted, if I remember correctly. And that is that you have to have basically a sprayer's license to access the map to be able to see what's going on. So we do have a protection there, I believe. We'll double check on that, but I'm 95%. So what this does, though, is that if you get sprayed by your neighbor, then their insurance has to cover the loss of your crop. We've had 9 reports of this in the last 3 years, according to ODAF. And this last year we had 3. One of them turned out to be a valid claim. So it's there's really not that much of it that goes on at this point in time, but this is actually a protection for growers. So we're good with that. Appreciate the bill. Let's see, House Bill 3929 is process validation. That is still alive and going into conference. So, that'd be really good. Again, that's something that while there are procedures for businesses that are up, especially processors, manufacturers, having this together really help those folks out and kind of lower that ridiculous testing burden that there is. Would qualify for growers too. So those are the ones that are kind of, good, not too worried about. Let's see. It's all good. Chris, morning, y'all. Amber, Chris, Andrea, Travis, morning, all y'all. Thanks for hopping in. All right, so let's get to the stuff that's kind of on yellow right now. You see it, okay, we're in the right ballpark, but might need a little bit of work. So let's see. House Bill 4055 requires utilities to report consumption of utilities to OMMA. It'd be nice to see that OMMA had a system that was set up that could really receive this information. It's not necessarily bad. We think it goes a little bit far in some places, like you're supposed to report rainwater collection. And, to a degree, there's a certain amount of growers that might see some of this as like proprietary information. Like, what we're going down here is this road of, we have to tell you exactly how we do like every step of the way. It kind of goes beyond an SOP. Like, let's say you're a grower and you've got your ways that you grow, which a lot of growers do things differently, good, bad, or ugly. So, do you want to have your exact formula of how you're getting all of your ppm right in your hydro grow? Do you want to talk about, I've got this particular type of fish that, does really well in aquaponics, and I've got this blend of feed that I feed them. I mean, do you want to give all that information away? There are folks that sell this information as consultants or proprietary systems. It could go for internal controls. Outdoor, it could be like, well, I've got this particular mix of compost. I've, collect X amount of, do we have to say how many gallons of rainwater we're collecting? I mean, that's just falling from the sky. At that point, we're not even using anything that's a burden on any sort of local water system, so it just seems like a whole lot of extra to require. It's, the baseline, however, on House Bill 4055, the baseline reporting of utilities to OMMA, that seems generally reasonable. It would be kind of nice to know what sort of footprint we're having. And, that data will probably show a decrease in illegal grows over the next year. I mean, it could be some interesting data. It's out there with publicly regulated companies. It's not going to tell folks enough. It's kind of like that. So 4055 could be good. I think a few of those items probably ought to be clipped out of there. Even if folks really needed to provide that data, I don't know that OMA would be able to handle it. at least not right now, not for another couple of years. And if so, what's the point? There's so much of that we don't require for other forms of agriculture. Okay, so House Bill 3971 is the OMA secret shopper bill, and what it would do is OMA would authorize OMA to give inspectors money to come in and act as secret shoppers, buy product off the shelf, take it, get it tested, and see that the COAs are right, that type of deal. Right now, they cannot legally spend state dollars on marijuana. So that's what it is. So that's what it would be. The state authorizing itself to actually spend money to buy product out of dispensaries. This would actually go a long way towards helping lab consistency. And it would also, if this goes through, which we're not opposed to this at all. There are a couple of things that might need to be tweaked in there. We're looking that over, but it would, for folks that are doing things, by the books. This is anyone, not big, not small, but anyone doing it on the books would benefit from this. So anyone doing it off the books, if they got serious with that program, man, they could run through, they could, if they got serious, they could run through a lot of dispensaries really fast without having to, hey, I'm an inspector here to inspect you, talk to you. They just swoop in, 21 Jump Street and purchase, a certain amount of product. And, if you're selling it to them without a patient card, you're not, if you're, not collecting sales tax or whatever, then you could have basically instantaneous issues. So that bill's got some teeth on enforcement, but it doesn't single out. It's not in favor of one side of the industry or the other, if that makes sense. So, 4056, House Bill 4056 is the bill to standardize lab testing. Good idea. We all know that we need standardization in labs. There is kind of an issue with it, however, which some folks have recently pointed out, and that is that what this would do, the way it's written, is it would give disproportionate power to the current state contractor, Metis, who's the one that runs the QC lab, would be able to just come up with all of the SOPs, and here's the equipment that you have to have for all of the labs. Now, is that a good thing? Not in the hands of solely the state contractor. We do have labs that are doing this correctly, and they need to have a say-so in what that happens, so that, say, this government contractor comes in, makes up a rule and says, your $2 million worth of equipment that are working well, that doesn't work because we want these that sync in with our system better. Well, what happens when they're not the contractor? So it's been recommended that in this, what they do is that OMA be allowed to bring together a committee of labs to have some say-so on it. There is a caveat, and this is very important. Understanding is that labs are required to have achieved ISO certification by this point in time. And there are a big number of them that haven't. There hasn't been enforcement on that. Again, it's a situation, law in place, hasn't really been enforced. And so what has also been suggested is that labs that have not, labs need to provide that certification for when they reapply for their licensure. If they don't have that certification, they've been asked for it for 2 years, it's a baseline quality control, why not have it? And then the other thing would, so combining those two together would be the folks that would be on that committee. There's like 6 or 7 of them right now, but you would have to have your certification to be on this committee. So it would need to be graduated in, but done fairly quickly to have some effect. The deal here is that it would really suck to have like overnight. The labs need a lot of help, but having, say, 2/3 of them disappear overnight would cause a lot of problems as well. So, anyway, Bill's good. Some suggestions have been made. We hope to see some of that common sense stuff thrown in there. And I mean, it could get us all a long way towards the goal that we want, which is quality control at the labs. Okay, here. Okay. And anyone that's just catching this midstream, we're going to talk about this later on, but State Question 818 and 819 have been cleared by the Supreme Court. If you just happen to pop in, we're going to talk about that tomorrow after we get a chance to review the ruling. So let's see, back to bills that are basically there. We've got a couple more to cover here, and then we're going to get into, looks like 2, 4, 6, 7 bills that have still we've got issues with. Let's see. Senate Bill 1704 is increased fines for diversion by businesses. Let's see. Okay, yeah, there that is. So 1704 is increased fines for diversion by businesses. We need to take another look at that. This was red, but it's now. I popped it up to yellow. Honestly, in all of this, I do not remember exactly why. I think I've got it noted in the Google Doc that we need to post analysis. But so 1704 on the watch list. Details on it, but what it basically does is it's in a cluster of 3 that were being supported by Oklahoma Municipal League, and it basically, if you're doing diversion out of your business, it's a $5,000 to $10,000 fine depending on first or second offense. I think there's a lot of stuff like that in place already, but it seemed like there was something in there that was harmful to patients that we flagged, and it's been amended. We'll double back on 1704. Okay, let's see. 3734 is a temporary license application, kind of like Senate Bill 1755 is, and it has some additional license requirements. So both Senate Bill 1755 and House Bill 3734 create a temporary license. 1755 does it clean, no additional reporting requirements, application requirements. Keeps the fee thing going the same. Senate Bill 3734, we had caught last week that the Senate author had amended it to raise license fees. That wound up being re-amended, and they got together. I think it was just kind of a snafu type of a deal, but they got back together. So license fees would not increase under 3734 temporary license application, but there would be a lot more reporting and application requirements. Some of them are okay. It wouldn't be bad to do it and have those requirements, but there are some additional requirements in there as far as insurance that would raise costs on businesses a little bit. So they would also require a lot more in-depth financial reporting for entities applying. And our real number one concern on this, I mean, we see kind of what's going on, but our number one concern here on this is how much of this is required for other businesses. Again, it's a parity issue. For example, and the insurance provisions have been worked on a little bit from what I saw. It's something that we need to really go back and look at some more. That's why we've got it on a yellow. 3734 isn't necessarily bad. There are just some things in there I think that, we might need to take a look at. And if you have time, take a look at it, let us know. Conversation's kind of going on that. It's a good thing. Temporary licenses are. Not all of these extra reporting provisions are bad, but we just kind of want to, see what parity looks like with other businesses. Okay, so we've got 7 more to go. Thanks everyone who's, checking it out. I know these get a little bit long, but I mean, we got like 28 of them. We didn't create this mess. So, uh, now the good thing is, again, I want to say that, 2/3 of all of this, almost 3/4 is good or leaning good at this point in time. So, let's get into the stuff that we've really been hammering on. There has been movement on some of these, and we are going to, need to continue to voice our concerns about it. So let's see, House Bill 2179, which is the license fee increases. It's headed to conference committee, but at the end of the day, again, this does nothing to prevent diversion. It hits the good guys, which only helps the bad guys. And 2179, when we're increasing fees, remember that the state is looking to drop the state income tax. They gave a big fee break to banks, including international banks. And just yesterday, we saw the governor hop out, and he is now asking and pushing to have a unknown employer, someone come and build a big factory, I think electric cars or something like that. And he wants to give them tax incentives to come and do it. Now, this would be a big deal for the state. I think it's supposed to be up in northeastern Oklahoma. Anyway, all of that, forget that. The point here is, regardless of what's going on, is its fundamental principle, okay? Everyone else is getting a break, yet they want to raise license fees on growers. It makes no sense. It's one of those deals where it's like the Oklahoma double standard is kind of what we got going on here. There's one standard for all businesses, and then there's this double standard for cannabis businesses, and that's what this is. So 2179, not needed. It just needs to go away. It doesn't do anything to help. OMA's got the money they need to operate. We're sending money to education. We're sending money to mental health. Like, this is just not needed. Not needed. So House Bill 3208 is the moratorium on grower, processor, dispensary licenses. Again, we're just not for the deal. OMMA has been now asked twice. They're on the record as saying this wouldn't have any effect. It wouldn't do anything to curtail things. And, that's the thing, is that, this is where the legislature, they're not taking enough credit for what they did, and what it is last year. When they did 2646, 2272, 1033, those bills that we saw come through last year requiring foreign attestation, giving additional funding to OBN, those things, we've started seeing that take effect right now. And so there's always kind of this delay in policy and effect in politics. And so the reality is a lot of these bills, like, say like 2173 or 3208, this license moratorium, all this is basically campaign fodder for someone. The actual effects of these bills would be detrimental, but it would appear as, the grow license numbers continue to drop, as they continue to have large scale interdiction against organized crime. All of a sudden it looks like these bills are what did it, and that's not what would be going on. Look, we're seeing the license numbers drop. We know a lot of us have friends have had businesses that have not succeeded in the market for one reason or another. And so we're seeing the natural attrition that you would expect in a free market right now. This stuff is just over the top, and it's just more than what's necessary. If it's not necessary, if it doesn't prevent diversion, and all it does is, stifle different, businesses or business models, And again, if the moratorium passed, we all know that what happens day one is it sets OMA back. They're going to get swamped with license applications. It's going to happen. People are going to stack licenses. So moratorium, it's not going to do anything. We need stability here, not random variable factors popping in. And we just don't want to go down that slippery slope. So let's move on. 4287, which is the pre-packaging bill. Again, Oklahoma double standard, guys. 4287 doesn't do anything to prevent diversion, first of all. They say, well, they're bringing in outside product, and then they're kind of adding it to the jar, and then they sell it, and that's why they say we don't need deli style, you got this big jar. But then, as written now, they say, but then they also say, okay, well, you can buy these maximum 3-ounce packages, but you can open up the package and deal out of the package. Well, that kind of defeats the point of pre-packaging. What's the difference between a 3-ounce bag and a, 16-ounce jar over here? Yeah, there's obviously some difference, but fundamentally, you're not stopping anything. And folks that are going to sell out the back door are going to sell out the back door. That's just all there is to it. Does it go in the jar first? Does it go out? Folks aren't stupid. If they're bringing product in the back door, it's not registering on the cash register. It doesn't matter. Total weight in, total product out. If the total product out is higher than the total product in, then there's obviously an issue. Almost got the data to deal with that. So, we just don't see where 4287 is necessary. I mean, at the end of the day, it's if we had parity, if we didn't have a double standard here, as with alcohol, then what happens is that bartenders no longer mix drinks. What are your proportions there? Everything would be like Capri Sun. I don't think folks are wanting that, and we're talking about the difference between poison and medicine here. So, let's see. 1697, Senate Bill 1697 requires grow licenses to all get a bond to pay for land remediation if they bail out on the property. This would apply to all grows, including indoor grows that don't have any property to remediate. So again, it's an additional burden on business that it just kind of cuts across the board. It maybe kind of apply to outdoor. I mean, we hear they're relatively inexpensive, but I mean, it's just more stuff that doesn't do anything. It's just meant to punish growers. So let's see. Last one is for right now is 1367. And that is, okay, so we've been hitting on that. And the 1367 right now, it was the bill that, it was, you get fined for sharing a joint. If, patients that share their medicine would get fined, and potentially if they work for a business, that business itself could get its license revoked. Now, this bill has been amended now. And what it does is they changed it to where if a patient sells product, then there's a problem. But what this ultimately does is, it doesn't prevent anything from going on that's going on. There's not the manpower to enforce something like that. And if there was, the reality is that what you have done now is this bill would double the penalty, because it'd be a stacking penalty on whatever criminal penalty you might face for that activity. So now what it would do is basically, if you were going to say run around and sell ounces, then you would get a greater penalty if you had a patient card than if you didn't. So at the end of the day, 1367, our opinion is there's not a whole lot that can be done with it. It's just not a good bill. It goes after patients. It takes us backward. We just don't need to do it. So let's see. Let me pop and see if there are if there are any questions on this, and then I think we'll go ahead and wrap this one up. Again, more information coming out on 818 and 819. We have passed the Supreme Court, so we're really super happy about that. Let's see. Yeah, good point, Jeff. Appreciate that one. Let's see. Yeah, no real big questions. So, yeah, well, I appreciate everyone for hopping on. If you've got, I'm gonna be on the phone a lot. I've got to double back. We're gonna look over what's going on exactly with 818, 819. We need to talk to Secretary of State. We need to, review the opinion. I understand that on 819 that they severed part of it, which means in both of these, and I'd said this, is that, folks say, well, you're going to pass the challenge. Well, of course we're going to pass the challenge, The question is are there parts that they may not like that would defeat us? Well, we have a severability clause in there, and top line what I'm told, and I want to give a shout out to Stephen Kale, who was our defense, who provided our defense on this. You know, he does other cannabis stuff, and you know, he was happy to hop on and help the cause and do it for the cause. And so we really appreciate his help on this, and congratulations, Stephen, on winning that. It looks like they may have cut out the expungement of records part on us, which is interesting because but they did it because we didn't adequately address it in the gist. I need to read this before I talk a whole lot of shit on this, but it's really curious what they did. I found out like 15 minutes before this live, so I'm gonna go read it before I, talk out my rear anymore, and we'll hop back on. We'll hop back on tomorrow. We'll hopefully get a post up later on today, but I want the day to review this, talk to folks, and we'll be back tomorrow with more information on 818, 819, and what we're going to do here to move forward. So really appreciate everyone that's been getting your 2 cents in, no matter what it is, however you feel on an issue, talk to them, and hope y'all have a great day. Thanks.